It's the state of Arizona versus Miranda. It's the state of Florida versus Gideon. And so for all of those cases, there is no, or was no, protection for a defendant to have his own attorney. Now, some states, and that was, like I say, from the 1780s up until 1963, when along came the case of Gideon versus Wainwright, and this case, for the first time, decided that a defendant in a state court also had the right to counsel. Now, the Constitution doesn't say that. It says in the Sixth Amendment, you'll have a right to counsel in a federal criminal case. How did they expand it? Well, right after the Civil War, we had another amendment added to the Constitution, the 14th Amendment. And the 14th Amendment, which was very concerned with fair treatment of all people by the states following the Civil War, you want to make sure that everybody's going to be treated fairly. That's where you had the everyone is granted equal protection of the law. That's in the 14th Amendment. And with regard to the criminal cases in the country, you had the right to due process. So anytime you're arrested in a state, you have a right to due process of law. Now, unfortunately, the 14th Amendment didn't specify, I can't stand still, the 14th Amendment doesn't specify what particular rights are included under due process of law. And so that's been a long, slow process that's still going on. And in the late 50s and through the 1960s, we had in this country what is called the due process revolution, in which the Supreme Court would look at specific rights like right to counsel, double jeopardy, right to confront your accuser, speedy trial, right to remain silent. All of these rights were added one by one to the this pantheon of fundamental rights, and they were what is probably still being used. They were they were nationalized so that these specific rights, when you look at them, they are so important that they should be included under this general rubric of due process of law. And therefore, from 1963, with the case of Gideon versus Wainwright, for the first time they decided that having your own lawyer in the criminal case was the right of everyone in the state courts. And actually, the Gideon case was sort of narrow. They only were talking in the Gideon case about having a right to counsel in the most serious criminal cases, that is, felony cases, or what we call in New Jersey, indictable cases. And these are cases in which, generally speaking, you face the possibility of being sentenced to a year or more in prison, as opposed to lesser crimes, which are called misdemeanors, where you, in New Jersey and most states, you can only be sentenced to a maximum of a year, and that year will be spent a year or less, and you'll do that time in a jail, in the county jail. So Gideon, and there are probably 7 or 8 times as many misdemeanors committed in this country as there are felonies. Fortunately, in 1972, 9 years after Gideon, they expanded the Gideon holding, and they made that apply to states as well. So today, if you're arrested for any crime in which you face the possibility of one day in jail, you are entitled to an attorney. Okay. Well, that's the background. And let me move on now to really the major thrust of the book. And I was talking to some students in the back, and in reading the book, they were mentioning that Essex County comes off pretty well. It's a model system for this country, and it's one of the most progressive public defender systems in the country, in New Jersey. You should be very proud. Well, maybe not proud, depends on what your perspective is. You know, if they're a real good system, they're turning criminals back out into the street. So from some points of view, having a good public defender system isn't such a good thing. I'm not going to take sides on that. Anyway, when I decided to study this subject of public defenders, and I wanted to do an intensive case study of one particular public defender operation in a big city, I chose Newark in Essex County for one major reason. It was close by. I was teaching full-time at Drew, and so it would be hard to pick Chicago or New York or Washington. I had studied those other cities when I had been working on other books on related topics, but you know, Newark was perfect because it was a big city with serious crime problems, and it was 25 minutes away. So I could teach my class and zip off and spend time studying that particular public defender system. And as I got into the study, and I spent about 18 months in Newark, which is where the Essex County program is headquartered, and interviewed. Now they have the office in Newark. They have approximately 50 attorneys working there as public defenders, and they have an additional 20 investigators to help them, and then they have a staff of secretarial support of another 25 people to help them. So it's a nice size operation, and I was able to interview, with about 2 or 3 exceptions, every public defender and every investigator, and then I spent countless hours really observing them in the Essex County Courthouse, which is located about a half mile up the hill from where the defenders are housed. They're housed in a very common-looking 10-story building in downtown Newark, right off of Broad Street on Clinton Street is where they're located. And they occupy the top 3, well, actually it's floors 5 through 7 of the Essex County Defender Office. So I began studying them and talking to them and watching them, and the more I got into it, the more surprised I was at what a wonderful program they had in terms of other public defenders systems around the country that I had studied previously. And so I pretty much came up with a sort of a minimalistic kind of dichotomy, and I broke public defenders programs down into 2 types. One type were the traditional programs exemplified by New York City's public defender program and also the one in Chicago. I'd spent time studying both programs for one reason or another. I had written a book on bail, and I wrote a book about judges, and these studies had taken me to those cities.